or contested. Content.
So you like I don't know what you're asking exactly. What exactly the question is, because we have gone through that entire process of the process of. Have you been in this class when we discussed the process of taking out a grant, the process of non-contentious probate from the first to the last?
Yeah.
So what is your question? I'm not getting your
Like I
question.
wasn't understanding, but maybe I'll go back to the recording. I see. I didn't understand it when you were taking us through it.
What do you understand? What is the process of taking out a grant? What do you start? Where do you start from?
Where you make an application.
So what part of the process is that you don't understand? If you know where you're starting from, then what is the confusion iko wapi?
I'll just go through the recording. I seek clarity from there.
That is not the question to my answer, or the answer to my question. What exactly is your worries? What is confusing you? Where is it that is getting confusing?
Like if I'm told to explain that process, I'll not be able to.
But you say
The procedure.
you need to be serious right now. That is a process we've discussed 10 times in 10 consecutive classes. That is something we have discussed in 10 consecutive classes. So there is no way you can say you don't know it. And even in the last class, we talked about it. That is how funny that is. We have discussed the process of conveyancing in every single class. All right? Where it starts from and where it ends. So, Omwanga, I'm still on your case. Unmute your microphone and take us through the process of what is the procedure, where do you start from and where do you end? Where do you start from and where do you end?
Unless you give me a moment, then
There's no moment. Just you're already unmuted. Please proceed and speak up. Where do you start from? And where do you end at? Quickly. Time.
a minute, mwalimu, and then I'll take it off.
There's no minute I'm giving you, Mwanga. Stop playing with me. Where do you start from? You want me to waste time, right? I'm going to waste time on you. Where do you start from? Let's start there. But I'm not able to
when
guide
you
you.
make an application, yeah?
I'm not able to guide until I know exactly where you're getting lost. So we're gonna walk with you from the first to the last, and then whichever place that is confusing you, we're going to clarify it as we go. I'm not telling you to give me the right answer. I'm just telling you, tell me what you know, and then we can pick it from there. So what do you know? So where do you start from?
You make an application to the registrar. And then they file
an application for what? An application for what?
For the relevant grant that you want.
Okay.
application is forwarded, is tabled before the judge or the magistrate.
What happens when you make the application before it is tabled? After you make the application, what happens? That application is
You
received by
file
who?
it, the registrar.
And then what?
You file it, and then it's tabled before the judge. After being tabled before the judge propounds the will.
Mm-hmm.
After that, the he makes a notice. Then the notice for gazettement is made,
Mm-hmm.
and then a gazette notice is published, and then the other party has 30 days to object. If there is no objection, mm,
Mm-hmm.
if there is no objection, a grant is a grant is given.
If there's no objection, the grant is given. Given to who?
To the person who applied for it, and then they appoint. Then there is a distribution of the a schedule of distribution is prepared,
Mm-hmm.
and then they get back to the magistrate, the judge, where the grant is confirmed.
Mm-hmm.
Yeah, that is all I can say.
Once the grant has been confirmed, then what?
Once a grant is confirmed,
Mm-hmm.
it's given out
To who?
to the administrator or executor of the estate.
Mm-hmm. And then wanapewa wafanye nao nini? Wakule ama walale nayo ama wavae? What are they supposed to do with that? That's what I'm asking. Mm-hmm. So that's been confirmed. They've been given the grant, and then what? What do they do? Mwenga.
They come the legal representatives of the estate.
And then they do what? What are they supposed to do? Grant ukishapewa na koti unafaa ukule ama ufanye nayo nini? Why is the grant there? Stop playing. Hey, why do you have a grant?
To confirm that you are the legal representative of
And
that
then do
estate.
what? And then how is that helping? After it has confirmed, yes. And then what? Mm-hmm. And then what?
Mm-hmm.
Stop laughing. Umefurahi, si ndio? Can you answer the question?
I'm stuck there.
You can't be stuck there. And trust me, we can stay on that point until tomorrow. So decide. That is an obvious thing. Why do you go to court to get a grant? Ndio ufanyie nao nini? Why do you
To
apply for
administrate
grant?
to be able to administrate the estate.
Then I'm asking you a very simple question. Once you get that grant, what are you supposed to do with it? Can you answer that question quickly and stop wasting time? Huh? So, confirmation of grant, and then what?
You are issued with the certificate of grant.
And then what? You have it now. What do you do with it? That's what I'm asking you. You now have it. It has been confirmed. It's in your name. Then what? Time is not on my end. We will stay on this point until you answer this question, Mwenga. So decide whether you want to take the entire 2 hours or want to take 1 second to answer. I don't mind either.
Thank you. Someone help me. Honestly, I don't know.
Nobody's going to help you. Nobody's going to see this exam for you. This is your exam. Nobody's going to help you in this question. And if somebody tries saying anything, I'll move you from this class and you'll never come back. Try me. So, Omwenga, you made an application for grant. You've been given the grant. Why are you applying for the grant first? This is a common sense question. Why are you applying for the grant? Why?
So that you will not intermeddle in the estate of the deceased.
Don't use the word intermeddle. I want you to answer the question as a layman. Don't use any legal term. Explain to me as a lay person. Why do I need the grant? Ndio nifanye nao nini? You can use Swahili. Yes. Why do people apply for grant? Omwenga.
To give them powers to administer the estate of the deceased.
That is exactly now they've gotten the grant. Now what do they do? You've applied for the grant, you've been given the grant, it has been confirmed in your name. What do you do next? Mwanga, are you okay? I'm waiting for you to answer the question. Answer the question.
They use. No, me, I'm not understanding the question. See, they use the grant to administer the estate.
That's what I'm asking you. The question is very simple. You're not listening, and I want you to listen and listen very good. You have applied for the grant. You've told me you make an application for the grant. It is taken before the registrar, the judge. It is gazetted. There's no objection. You get the temporary grant. You've prepared the schedule distribution. You've made an application for confirmation. It has now been confirmed. You have it. Then what next after that? What next after it has been confirmed in your name? You wanted it to be confirmed. It has been confirmed. Then what next? That is simple. That's what I'm asking. Answer the question. Mwenga, stop wasting my time.
Report to the court on the schedule of distribution.
What schedule is that? I'm asking you a question. The question is this again. I'm not very good at Swahili, so I will not speak Swahili. But I'm going to say this. You have applied for the grant. Why are you applying for the grant, Omwenga?
To distribute the estate of
now
the
you've
deceased.
been given that grant. You've been given that grant. It has been confirmed in your name. What do you do? Yesu Christo. You've been given the grant. What do you do with it? Okay. Wanga, you're wasting my time. Can you unmute that microphone and speaker? The last time. You're
You
wasting everybody's.
distribute you use it to distribute the estate of the deceased person.
You know, you're playing, and I don't like people that are playing with my time. Stop playing. Stop playing, please. You are clearly saying that you apply for the grant to distribute the estate, and I'm now telling you, fine, you apply for the grant, you've been given that grant. What is the next step? So let's go back. Start from the first one. What is the first thing? Where do you start from? Let's start from the beginning. We'll do this until you get it right.
After you receive a grant, you go prepare the
No,
schedule of distribution.
no. The first thing you do, your great grandfather has died. You are the advocate in your family. They have come to you for advice how to deal with that estate. Now, what is the first thing you're going to do? What is the procedure? Number one?
We start again.
Yes.
Application for the relevant grants.
Okay. You make an application for the relevant grant, and of course, in this instance, the relevant grant means that you're going to apply for either a grant of probate, a grant of letters of administration intestate, or grant of letters of administration with written will annexed. You've applied. Next.
And to the registrar, and then the file is tabled, or the application is tabled before a magistrate or a judge.
Okay. When is it tabled before a magistrate, and when is it tabled before a judge?
If the value of the estate is more than 20 million, it's tabled before a judge. If it's below 20 million, before a magistrate.
Okay, we're doing well. We're doing very well. So it has been tabled before the judge. What next?
And then the magistrate will, if there is a will, the magistrate will propound the will.
Next,
If,
we're doing well.
if no will, make order for a gazette notice to be made.
Okay, it is gazetted. There's no will, it is gazetted. It has been gazetted.
If there's no objection, after 30 days, an administrator and a personal representative is appointed, who then goes and prepares the schedule of distribution. And after preparing the schedule of distribution, brings it back to the court. Before it goes to prepare the schedule of distribution, is given an interim grant, goes with it to prepare a schedule of distribution, and then brings it back to the court. If the court is satisfied with it, they give him don't know whether we call it a permanent grant, yes, with the certificate.
It's not called permanent. You just get the grant is what? The grant is? What do you apply after you prepare the schedule of distribution? What do you apply for?
For confirmation of the interim grant.
Once you apply for confirmation of the interim grant, what do you get?
The interim grant is confirmed.
It's confirmed. You get a certificate of confirmation of grant. It has been confirmed. What next? That is where we are stuck. What next?
Now, after being confirmed, you are the legal representative of that estate, and you can.
And then what next? What next?
The schedule
Stop. Hey. You have the grant. You have the grant.
No.
You've gone to court. Listen, don't take me back. You have the grant, you are in court, whichever court you've gone to, you've been given the confirmed grant. Umeshika kwa mkono yako. What do you do? What do you do with it? Do you go home and sleep? Do you start eating it? Do you put it in your pocket? What do you do with it? Now you have a confirmed grant. The grant has been confirmed. What next, Omwenga, Mora? Is that the end of the story or what? What next? You get it has been confirmed.
Now, with the schedule of distribution you had, you can now go and distribute the estate.
And that is what I've been asking you all along. Jesus Christ of Nazareth. I don't know whether it was coming from Nazareth or which place. And I'm asking you very well, why are you getting the grant to distribute the estate? And then I'm asking you, now you have the grant, what do you do next? And then you're telling me you don't know what you're doing next. Are you okay? Stop playing. These are things we've done before. And you know very well you know these things. And you're playing, taking me round and round and round. So that is the process of non-contentious probate. Exactly what you're asking. You get the grant, you go and confirm. I mean, once it is confirmed, you go distribute the estate. Get the grant, distribute. That is why you needed the grant. Now you have it. What next? Distribute the estate. Distribute the estate. Jesus Christos. Mwana wa Mary. Mwenga. Are we on the same page?
Yes.
Yeah, so we said after confirmation of grant, what next?
Distribution of the estate.
Yes. So why are you taking time to talk? I don't like people. Anyway. All right. So let's go to something else, Mwenga. That is a procedure. That is a process. Please, we have talked about it. Now this is the 13th time. 13th time, because we've talked about it. We've talked about it from the very first class up to this class. Every time we talk about it, because that is the process of probate. Like I've said, you cannot understand probate if you don't understand the process. So that is what we have we've gone through. The same thing. There's nothing different. So you just need to understand the procedure, not just as a lawyer, but also as a lay person, so that you don't forget it. Just know that if you're advising somebody who is lay, what do they need to do? They do this, they do this, they do this, they do that, they do that. From this, we go to this, we do this. We have done this thing in this class. God knows we have a lot of times. So please, the first thing, and this goes to everybody, the first thing that you need to confirm is make sure you have that process at your fingertips. It is the same process, whether it is non-contentious or contentious, it's the same process. What do you, guys, that is the only thing you need to know in probate. That is the only thing. And then you'll be fine. Okay? So let us now proceed to something else. And that something else is I want us to go to the preparation of this question. Anyone with a question? Anyone wants to be grilled, can put your hand up. And we can start with you. Any question that you have before we get to this question 5? Somebody read it quickly. Guys,
Question 5. Question 5. Your old client, a 70-year-old Bwana Mponda Mali, has visited your chambers for discussions relating to his recent anxieties regarding his state of health. He fears that he may not be having a long time to live, considering that he has recently been diagnosed with liver failure. He is therefore on the view. Yes?
Proceed, yes.
Okay. He is therefore of the view that he needs to put things straight so that even in the event of his death, then his estate should not waste away. Consequent upon your discussions, he has generated a list of his properties and required that you use the information provided therein to draft a will for his review and ultimate execution. The information is as follows: name Bwana Mpondamali, spouse Gentrix Nyabito, children Clarice Mali, 30 years old, Jeremy Mali, 27 years old, Kamati Mali, 20 years, and Kazingumu Mali, 17.
Just stop there. Because of time,
Yes.
let me just summarize what the facts are. So this person has given you the children, the spouse, the children. He has given you his assets. Okay, he has given you his assets, and then we have the personal and household effects, those such things, and then he has given you the mode of distribution. The mode of distribution here, who is supposed to get what, and then the witnesses. You can have any witnesses that you have. You can provide the witnesses that you want to provide, and then he has provided a will, a direction in terms of his burial, his Thurwa residence. The executor of the will has been provided, and then the alternate executors have also been provided. Now the question is telling you to proceed and prepare Mr. Pondamali's instructions or execute the instructions. Okay, so the question is asking you to prepare a will, Mr. Pondamali's will. That is what the examiner is trying to check whether you understand what are the requirements in as far as the will is concerned. What do you need to have for you to prepare the will, or how do you prepare the will? How is the will supposed to be prepared? That is exactly what the examiner is interested in. That is what the examiner is asking you about. Okay, so because of time, we will not go through each and every fact, but we are going to go through the process of making a will. Making a draft will is a very simple document. Making a will, I think this is one of the first time it was being set, and yes, they can set it again as many times as they want. So what you need to have is just the general idea of what goes into a will. So let's go into a sample here of what will be in a will. Every time you get a will, every time you get a question asking you to draft a will, then you just need to understand what to provide. It's a very simple thing. The person has given you who the executors are, the properties, the beneficiaries. So simply copy paste everything in the question and put it in the will. That is all that you need to have anytime you're preparing a will. So just copy paste what you said in the instructions and have it in a will. All right, so let's go through the process. Normally, the first page is you don't need this. You don't need this. This first page is not needed. You don't need this one. It is not a requirement. That is only for people who are doing that in practice. But you don't need a cover page in an exam. Okay. So what is it that you need to have? Okay. You need to have whatever you can see on the screen. You don't need to have this. Okay. That is for purposes of exam. You don't need that. For purposes of exams, you don't need that. Okay, so what you need is just this first one. Let me just have it like that. Yeah, so that is what you need. So the last will and testament of this person, the person you've been given in the question, person XYZ. Okay, and then you indicate this is the last will and testament of person XYZ of PO Box this, who died, or which is made on this, because at this point he has not died. That is the point he's making the will. Okay, so this is the last will and testament of this person. Let me put that in bold. Of this PO Box or made at this place of PO box this and this in this specific number of years. So that is testament of, let's say, Abdallah Abdul Qadir of PO box this and this and this, made on the 9th of September 2024. So that is essentially the first thing. The next thing that you need to have in a will is also capacity. The question of capacity. You don't need it like that. You don't need it to always indicate that this person had capacity, because it's not a requirement for drafting a will declaring capacity, because we shall assume capacity. Unless there's evidence to show otherwise, we shall assume that the person had the capacity. We assume that this person was capable of making that specific will at the time that he made it. So if there's evidence later, we can challenge it and then, of course, have the will declared invalid. But we don't have to declare the capacity in the will. So you can have that, or you can just ignore that. Okay, that is the question of capacity, where you're saying that I declare that I'm an adult of sound mind and memory, having the full understanding of the nature of the business of making this will. And then the other idea that you also sometimes have in a will is this is a standard will, of course, in practice, not for exams, but even for an exam, this is what you draft. Simple, direct to the point. Now, revocation of previous wills and codicils, you can have that. Again, lack of that does not make it an invalid will. So you can indicate that I hereby revoke all my wills, codicils, and testamentary dispositions made by me at any time prior to this date. Okay, that is that. And then the question of estate and domicile, which also you don't need to declare the question of domicile, and then the applicable laws, you don't need that as well. So I'm going to just make it easy for you because of so let's have that. Okay, so once you have the question of capacity and revocation of wills, now you go straight into beneficiaries. Who are your beneficiaries? Give me 1 second. Who are the beneficiaries? Okay, that is the next thing that you want to have. Every single will must have the beneficiaries. Every single will must have beneficiaries. So you must indicate who your beneficiaries are. Okay, you confirm that I've confirmed the following are my beneficiaries, or the beneficiaries to my estate. And in this question, you get the children, also you get the spouse, and any person who has been mentioned as a beneficiary. You list them there. Okay, and then the executors and my trustees. Okay, so you come back here and remember that under this part, you list your beneficiary. Your beneficiary will have to be your kids or any person you want to benefit. I mean, you want to enjoy your estate. It doesn't have to be your children. You can have children, but your children are not included in the will. The will doesn't have to include your wife or your kids. The will still be valid even if there's no mention of your wife or your children. So you give us your beneficiaries, and then you come and give us your executors. Again, the executors are being provided for in the question. So you just go to the question and copy paste who will be an executor in that instance. Okay, like given in the question. All right, and then in terms of the question of burial directions, in terms of burial, of course, that has been provided for in the question. You go to the question, you ask yourself, how did this person intend to be buried? In the question, it says that he will be buried next to the mother at that specific village. So you indicate that as well. And then you come to the schedule of distribution. Okay, you come to the schedule of distribution, whereby you are going to be bequeathing the estate to this and this and this and this and this person. Now, You don't have to categorize. You don't have to categorize immovable assets, movable assets, household equipments, land. You don't have to do that. You can just list all those properties together and give them to whoever you're giving them by saying, I hereby bequeath my property as follows, or I hereby bequeath my piece of land XYZ to this person, my Range Rover to this person, my the money in this account to this person. So you don't need to categorize them in terms of your household items, your movable assets, the land, the movable, the land and building, your money, the shares, all that. You don't need to categorize them like that. Okay, because of course, if you're in an exam, you don't have that time. You don't have the time. And then after that, you come and give direction in terms of the liabilities of the estate, in terms of payment of debts, and then give any direction in terms of your residuary estate, if there's any residuary. Sorry, and then you sign your will. Okay, you sign your will, and then that is that. So let us do away with this template, and then try and make another template so that everybody can understand from the layman's perspective. So I'm just bringing up my screen. Let me bring up my screen again. Any questions so far? Any question? Ask the question, proceed and ask. As I bring up the screen.
Jackson, hi.
Mhm.
I just have a general question, because I think what really messed us up with this drafting the will is keying in the details. Like, everything needs to be fed from the information that is gotten. As long as ume feed in the witnesses, those important parts, like capacity and all that, because the time was not on our end to be
There's
able
so
to
much
feed in
time.
all those information that is been given.
Yes, you have to feed all of them. That thing cannot take you more than 30 minutes. You have to
No,
feed.
it's
Don't take.
because the information they give is so much, like, a lot of small details, but a lot of, like, there's so much to feed in. And that is one of the questions we were like, we'll do it maybe later, the last question, but time could not allow us to feed everything. So I don't know if it's everything needs to be fed.
You
The
must
time
feed
can be fed.
everything. There's a lot of time. There's a lot of time. There's a lot of time. Please. You have to feed. When somebody gives you their will, you have to do exactly what they want you to do. You can't leave information out. You can't leave information out at all. Okay? So yes, you have to just feed everything. So that means manage your time. Don't say too much. The thing is, all the questions that are set in a paper are meant to be answered in the same paper. Okay, within the 3 hours. So if you waste your time talking about a lot of things in question one, you have to discuss every village in question one, and then talk about every community in question two. You will not get time to do this. And guys, it doesn't matter which question you start with, whether you start with question one or you start with question 6. There's no magic. There's no magic of you managing time. Starting with one question or the other doesn't manage your time. Okay? Because question 1 is 1 hour. Whether you start with it or you don't start with it, it is 1 hour. The remaining questions are 30 minutes each. So you need to stick within that timeline. So if you start with question 1, do it in 1 hour. If 1 hour is over, please mute your microphone. If 1 hour is over without you completing that question, then you need to go to another question and leave it. If you're starting with question 6 and you need to do it in 30 minutes and 30 minutes is over before completing it, leave it alone. Don't continue writing after the 30 minutes you gave that question is over. Because if you do, you are eating into another time, and it's chances are you're not going to finish. And that is for conveyancing, that is for civil, and that is for probate, because that is where the time is going to catch you. Civil, drafting. Probate, discussing the nitty-gritties, the same as conveyance. Don't talk too much. Straight to the point. You don't need to explain nothing. Straight to the point, move on. Straight to the point, move on. Straight to the point, move on. Don't, like the will that we're doing right now. Don't write nice things. Don't write nice things. Don't say, oh, this is my last will and testament. Having lived my 70 years of time, I have consciously done. No. Don't write those nice things. Don't waste the time. So the time is there. There's a lot of time. 30 minutes is a lot of time to just copy paste that thing. Just copy paste quickly, and don't copy paste in a manner that the examiner will not even read what you're saying. I hope that is clear.
Yeah, that's in order.
So this is I want us to go through it now. Not really word for word, but I want us to summarize a will. Let us summarize a will. So what you're going to have here is that this is the last will and testament of James of PO Box 123 Nairobi. Okay, made on this dash day. You have to tell us the date of dash 2024. Okay, full stop. Are we together up to there? You don't need to give us your capacity. You don't need to. So revocation of previous wills. There's usually an attempt to speak a lot when you're answering these questions. You want to say something nice, you're like, wacha tuiongeze hii ingine. Let me just add this statement here. Let me just add. You'll keep adding, and then you will miss the point. Because the more you add, the more time goes. Time is very short. 3 hours is very short, but it's sufficient for you to answer all questions. So for instance, this one, okay? Don't start saying that I hereby revoke all my previous wills and testaments. If there's any that I had made consciously or unconsciously, I hereby declare them null and void. You're saying too much. Just come and say under that, all my previous wills are hereby revoked. Full stop. Full stop begins with the next one. That is my. Okay? Full stop, move to the next. All my previous wills and are hereby revoked. Guys, are we together? Are you seeing what I'm doing?
Yes, mwalimu.
Good. Okay. And then you come and write beneficiaries. Beneficiaries. So you come and just tell us there, Control B. You come and indicate there that the the following shall be my beneficiaries. Now, in an exam, you don't even need to write that paragraph. You just proceed and go straight. Okay, so John, Mary, blah 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 blah. Okay, you're done with the beneficiaries. Okay, you're done with the beneficiaries, and then what next? So guys, don't go into a lot of details. Don't go into a lot of information. Just proceed straight into the point. Okay, so you give us your beneficiaries, and then now give us your executors. Executors, and then indicate the following shall be my, or shall, yeah, my executor shall execute this. We have my executor, or here I pointed the executor. You can say it in any way. So come there and give us the name or the names. So let's say Mercy, for instance. Kamiri John, are you in prison? And why do you have blue and light reds in your yeah? Why do you have blue and light?
What?
Okay, so the executors, you'll have the executors there. You'll have the executors there, and then you will have disposition of my body. Please, Kamiri John, mute your microphone. Okay. And then you indicate how you'd want your body to be disposed of. Okay, by indicating that upon my death, I shall be buried. Let's say in whichever place you want to be buried, in Kiambu, next to my mother or next to my father. Okay, or you shall be cremated, whichever, or your body shall be donated to the research, whatever you want to do with the body after that. So that is the question of disposition of your body. And then now you go to the question of distribution now. Okay, you go to the question of distribution. Okay, and then you just indicate that I hereby bequeath my estate as follows. Okay, with as follows, and then you're going to have one. What goes to who? 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 Guys, are we together? My house.
Yes, mwalimu.
Shall be transferred to my daughter, Mary, for instance. Okay. And then you go, dated, not, not dated and signed, dated and signed, and Nairobi, this dash day of dash 2024. And then, of course, you have the place for signing of the executor. You're going to have there, not the executor, sorry, the testator, the maker of the will, is going to execute his will there. Okay, so let's say our person was James. So James is going to have his will signed there before. So we have the two witnesses. Okay, before we have witness number one. Witness number one. We're going to have witness number one there, and then witness number two. Number two. Witness number two. Give me 1 second. Yep. So witness number two signs there. Your will is done and dusted. You see, we have only used one page. Your will is done and dusted. Guys, are we together? Are you getting what I'm saying? So don't go into aesthetics of trying to write things that are not needed. Just make sure that the will is properly provided for. Who is the beneficiary? Who is the what is the property? Okay, so that is exactly what you need whenever you are writing a will. That is all. That is all you need, guys. Do not complicate your life making a will. You're in an exam, you're not in practice. In practice now, you will make even 30 pages of a will trying to say nice things. You know, that is practice. But when it comes to exams, straight to the point, just go ahead and look at what the examiner provided for in as far as the question is concerned, and then copy that into the exam, into the paper. If you're told that there are alternative executors, you just write it there. Just say alternate executors, this person and this person. Guys, is that making sense to everybody?
Yes, Mwalimu.
Yeah, so questions, let's take questions and then you can go to something else. So it's the same thing. This person you've been given his name, Bwana Mpondamali. You've been given his beneficiaries there. That is his name there, the spouse. You've been given the children, the years. You've been told there's money in the bank account. That is that. There's 2 million in shares. That is that. It's real property, which is 2 acres of undeveloped property. That land, and that land. And then there's personal effects. And then there's the question of the mode of distribution, where they're saying all properties to be distributed to the beneficiaries in the ratio of 2 to 2, 2 to 2, 2 to 3, and then to 4, in favor of Gentrix, Clarice, Jeremy, Kamati, and Ngumu, respectively. Okay, except cash in the bank of Africa's reinsurance branch, which is to be donated to Bwana Mpondamali, and the shares in Kila Kitu Sacco to be distributed in line with my nomination. So essentially, you don't even need to go into the details of who is getting what. Just provide the list of assets, like it has been provided here. Provide the assets, and then once you provide the assets, this question was very easy. You don't need to go straight because this person doesn't say. Remember, this person doesn't say this land shall go to this person, this shall go to this person. No, he doesn't say that. He's only saying that these are my assets, money in the bank, that. So you copy paste this money in the bank. Let me come and highlight that for you. So there, up to that point, okay? And then again, this side, again, up to this point. You know, this is the only thing you needed to have copy pasted in your will, that these are the list of assets. Okay, once you copy paste that, then you come and give us the mode of distribution, where this person has summarized. He has not gone to specific, he has summarized. He has said that all the property to be distributed to the beneficiaries in the ratios of 2 to 4, 2 to 2, 2, 2, 3, 4, in favor of Gentrix, Clarice, Jeremy, Kamati, and Ngumu, respectively. And then it has also said, except cash in the bank, Bank of Africa's reinsurance branch, which shall be donated to Bwana Pondamali's foundation. And then the shares in Kila Kitu Sacco to be distributed in line with her nomination. And then you provide the witnesses. And then you come down here and say directions as to the disposition of the body. That is, the burial site shall be my Thura residence next to my late mother's, the executors, alternate executors, full stop. So there's really nothing of trying to determine who will get, there's no mathematics to be done here. That maths will be done after or during distribution. For you, you just copy paste what is there. Okay, actually you could get all your marks by just copy pasting everything word for word and then including a date and a signature for both witnesses and the testator. That is all you need to have done in that question. Any question in terms of preparation of wills? I'm happy to answer that right now so that we can move to something else. Are we together? Guys, are we together to proceed?
Yes, we're
Okay.
together.
Read question 6. Question number 6.
If I may, Mwalimu, question 6. Joseph was a very wealthy individual who enjoyed the finer things in life, especially the company of young women. As a person who subscribed to the African traditional custom and traditions, he married his 3 wives under customary law. From these marriages, he had 6 children by the first wife Anita, 7 children by the second wife Priscilla, and 4 children by his third wife Jane. In the course of his dalliances with young women, he met and fell in love with Janet, a beautiful model that he supports by paying her rent, her daily needs, and for her college education in exchange for her company. He is also occasionally seen in the company of Betty, with whom they share a 2-year-old son. He provides for Betty and his son's financial needs. In addition to his children, Joseph has 3 young school-going boys that live with his first wife Anita. These boys are his late sister's children, who he welcomed to his home and treats as his own. In addition to this, Joseph routinely spends around 2 million shillings a year paying for school fees for various children from his native village. He intends to do this every year for the rest of his life and wants his children to continue the tradition after he dies. Joseph is always accompanied by his driver and personal assistant, Jim. Jim has worked with him for the past 30 years, and Joseph has always wanted to reward him. Now that he is advanced in age, by giving him a substantial amount of money and a piece of land that he can retire on. Being a traditional African man, he believes that writing wills was a colonial concept. Mwalimu, kindly scroll.
Okay. You can't see my screen?
Now I can. Being a traditional African man, he believes that writing wills is a colonial concept that lawyers use to line their pockets. But his first wife, Anita, has convinced him to see a lawyer. He has come to your chambers to consult you. Using relevant statutory provisions and decided cases, advise him on the following. A, how his estate will be divided in case he dies without writing a will. That is 5 marks. And then B, since he is adamant that he does not want to write a will, what he can do to still provide for all of the people that depend on him.
All right. So, how will this estate be divided in case this person dies? In case this person dies without writing a will, how is this estate going to be divided? How is this estate going to be divided? Somebody wants to take a try. So first, you need to understand that this person is married to 3 wives. Is polygamous. Okay, he has 3 wives. From the 3 wives, he has 6 children with the first, 7 children with the second, and then he's also having 4 children. So total, we are looking at 17 children with 3 wives. Okay, and then you come down to the question as well. There is Janet that is taking care of, paying her rent and all that. And then there's Betty with a child. So there are an extra child there of Betty's son. Okay. And then in addition to Joseph's children, there are also 3 young school-going children that Joseph had taken in as part of his children. Okay, so there are 3 children again. So far we have 17 kids. His plus actually 18 children. Okay, plus 3 children that are taken in. So that is 20 children. And then we have there is 2 million shillings paid every year to the native village. There's a driver, gym, and then so those are the people that have been mentioned. So how will this estate be divided in this question? Jennifer?
The estate will be divided according to the rules of intestacy. And given that Joseph is a polygamous man, we will focus on Section 40 of the Law of Succession Act. And so in division, as per Rono, the estate will be, it will be divided equal shares according to the number of children, and with the 3 wives being the additional units, and then the children of his sister will be included under Section 29 of the Law of Succession Act, and then There's something else I'm leaving out. I think I'll get, yeah, those are the people who will benefit. Janet doesn't benefit, Betty doesn't benefit. Yeah, I think that's how I'd answer it.
Okay. Somebody else? Somebody else with a different perspective? Joy?
I'm in agreement with the division through intestacy, but mine is a bit different because the state, the owner of the property, Joseph, wants to continue providing for the children that he pays for school fees for the rest of his life. And he also wants to encourage his children to do the same. Maybe he can create a will just for the children that he supports, and then now the rest of the property can develop.
Joy.
Yes.
This guy has died without a will. He has died without a will.
Yes.
So why are you telling him to make a will and he has died without having a will? Harris?
Okay, from my end, I will go with what Tianga has discussed, and what Joy is telling us. I don't know whether I'm correct, but when we come to the rules of intestacy, properties goes to the blood lineage, and if he wanted to continue supporting the other children, he would have written a will so that now maybe he could have left a trust that is going to cater for.
You're not answering the
Yes.
question. The question is, don't advise this person what he could have done. He has died without a will. How is the estate being distributed? A, that is part A. How is the estate being distributed? He has died without a will. So how are we distributing the estate? That is the first part of the question.
I would have gone with Tianga's answer.
Okay.
Yes. Plus now I will add Betty's son.
Okay. Anybody having a different perspective? Omogeni Nyamoko?
Yes, I was trying to unmute. Mwalimu, thank you. I will go with the first speaker, Tianga, and then maybe the children that are, the blood children, yes, and the wives, they are the people who get the faster entitlements. Now, the children that was supporting in the village, it will not be possible unless now maybe they come and go to court and say they were depending on him, and they would want to get a provision for they would want to get a provision from the estate of the deceased. Maybe then the court could consider that. But as it is, that's how this will be shared. The driver, if he was to give him something, could have given something when he was still alive. and ensure that it transfers it to him. Now that the guy is deceased, the driver will not get anything.
Okay. All right. Omwenga, Mora.
Sorry, to me, I'll say first, I'll add on to what Tianga said, that the personal and household items in each house will remain there, plus now the children and plus the wives being, the children will be units, plus the wives being additional units. And I don't know whether Betty and who is the Betty can petition for reasonable provision, though that one I'm not sure. Betty, before the grant has been issued, if they can petition the court for reasonable provision, if they can be able to prove that the deceased was supporting them.
Hey, why is Betty petitioning for reasonable provision?
Not Betty. How is this? The person they were having an affair with, I can't remember the name. Was it Betty?
Why are they petitioning? Why are they petitioning for reasonable provision?
Because it was providing for them prior to his
Who
death.
can, Tianga, who can petition for reasonable provision?
A person who can be able to prove that the deceased was taking care of them prior to his or her
So
death.
for today, if somebody was providing something for you, can you just wake up one day and just go and petition? Tianga, is that what we have? Not Tianga, sorry. Mora, is that what we have said before? Who can petition? So any person can just wake up and say this person was providing for me. I need the estate.
Maintaining them.
So the question is, who can make an application for reasonable provision? Mora Omwenga, tuko na wewe tena. Welcome back.
A person or an I can say a dependent or a person who was being maintained by the deceased immediately prior to their death.
No, Mora. No, Mora. Pick somebody else to answer that question.
Paris Mwigai.
Paris? Paris?
Okay, I think it's any dependent who feels that have been left.
So the question is, can Betty and these other women that this guy was having an affair with petition for reasonable provisions?
No, they can't.
Why?
Because they are not dependent.
Yes, they're not dependent. So Mora, these people are not dependents. They are not dependents. Are we together? They're not dependent. The person who can make an application for reasonable provision is a dependent. They must be a dependent. They must be a dependent. Either their children, their wives, or their children that are taken in, or their actually relatives under section 29A, B, and C. So you cannot petition for reasonable provision because you are a girlfriend who was having fun with the deceased person. Thank you, but no. We thank you for your services and you move on. Okay? You cannot unless you are a wife, unless you are a child, or you're a relative. In that instance, under section 20, under section 29B, in that instance, you have to show maintenance. So girlfriend, no way. Okay? Girlfriend, no way. Are we together? So girlfriend is not dependent. Yes, Nyamoko.
Yes, Mwalimu. In the question I saw from the fact stating that there's a girlfriend that they were sharing a child with.
Mm-hmm.
Now, if the girlfriend is able to prove that that child belongs to the deceased, then that child will be entitled to a share of the estate of the deceased. And maybe then
That is the
that lady
deceased
maybe.
person's child. That is the deceased person's child. Remember, the meaning of a child within the act does not mean the child you give birth to in your marriage. No. The child you gave birth to. It doesn't matter whether you gave birth to them while married or not married. So long as you are the person that fathered that child is your child. Okay?
Thank you.
Yes, so the definition of a child is inclusive of any person that is given birth to alive, provided they are given birth to alive by the deceased person, and of course, at least within the first 1 year of the deceased person's death, that person is a child. So in this instance, this is what is going to happen. Now we have the people that will be inheriting from this estate, who and who and who and who. Now, this entire estate, because it is one that is being distributed under the rules of intestacy, everything will go to the dependents under intestacy. And that will include all the 3 wives. Okay, all the 3 wives will inherit from this estate as a matter of right. And then we have the 20 children. Okay, the 20 children, the first 17 are the children that are given birth to by the deceased person. Automatically, these people will inherit from this estate. And then, remember, this person also took in some children and treated them as their own. I mean, as his own. Okay? See what the question is saying. So the 3 young school-going boys that live with his first wife, Anita, these boys are his late sister's children who he welcomed to his home and treats as his own. Okay? And therefore, those key children also will form part of the deceased person's children. So they are also part of that estate. So that is the 20 kids that I'm talking about. The 20 kids. So out of the 20, the 3 are taken in. The 1 is the one out of wedlock, the Betty's child, and then the 16 are the ones that he gave birth to the 3 wives. So that is the first one. So all these kids together with the 3 wives will be how many people? So that is 20 kids plus 3 wives, 23. So this entire estate will be divided equally, okay, among the 23 units. Because remember that in intestacy, where there's polygamy, then each child is regarded as a unit, with the surviving spouse being an additional unit. So the entire estate is going to be divided among 23 units, of course, with the spouses making the additional units. And then the household and personal effects, just like I think that is Nora Mwenga, the household and personal effects of the deceased person will remain in each house, whichever that house is. So all the personal and the household effects will be inherited by the spouses. The surviving wives, depending on what is in their house. So each surviving spouse will retain the personal and the household effects of the deceased person in their respective houses. So whatever you left in your house, that is what you will keep. So that is how the entire estate is going to be distributed. Personal and household effects will go to the three wives, depending on what is in each house. And then the entire estate is going to be divided among the 23 units. How do we get to 23 units? We are going to have the 17 children, 17 kids, plus the three additional wives as additional units. So that is, actually the 18 kids, and then the three. Am I doing the proper math? Jesus, how many kids do we have first before I confuse this thing? We have 6 children plus 7, that is 13. We have 17 children plus a son, 18 kids. 18 plus 3 is 21. So we have 21 kids. Okay. And then we have 3 wives. So that is the total number of units would be 24 units plus 3 additional units. That is 27. I hope I'm doing the math correctly. So where are we getting the 27? This person had initially 17 kids with the wives, the 3 wives, and then there's 1 additional kid that is out of wedlock, so that is 18. And then there are 3 kids that he has also taken in as his own. So those are, that is 3 plus 18, that is 21. And then now there are 3 additional units, which are the wives now. That is clear. Any question on that front? Saina? Question B? Saina?
Yes, can you hear me?
Mm-hmm.
Mwalimu, I've heard you well. Now that the estate is going to be divided equally among all the children and the 3 wives. Now, there are children here who are below 18, they are underage. Can Section 41 apply here, that their property will be held in trust until they attain the age of maturity?
Yes, so if you are told that they are their age below the age of 18, of course that is a silent rule that whatever is given to minors will be held for them in trust until they get to the age of 18.
Okay, thank you.
Yes, and even in that regard, the grant will be issued to at least 2 administrators, not 1. At least 2 administrators. All right. Now, since this person is adamant and does not want to write a will, what can he do to still provide for the people that depend on him? What is the alternative here to the will? Somebody? You can answer it quickly and then you go to something else. Guys, you guys are not speaking. Tianga, Jennifer?
This is just a trial, Mwalimu. For the children in the village, maybe he can create a trust for them. And I think also including his children to provide for them. And then maybe for Joseph, he can gift him as a gift inter vivos. And I can say donation.
He wants this thing to happen after his death.
After? Oh. But to still provide for, but that is not what the question has not specified after his death. He'll still have provided for them if we say that.
Yeah, but this is probate, really. What I'm saying is that this is probate.
yeah.
So instead of having a will, what can he do to ensure that after he has died, the people that depended on him can still enjoy, can still enjoy his estate?
So inter vivos can't apply here.
That would not be a bad idea.
Okay. Yeah, maybe a trust and maybe nomination. I would go that route maybe.
Okay. Brenda Mithika, what do we need to do here?
We could go the principle of survivorship way through
Survivorship, how?
through joint tenancy or joint ownership, Mwalimu.
So how is that going to work? Tell us how it's going to work here.
For the assets like the property, the wives or the children will have the rights of survivorship.
So what do you do? Tell word for word. What do they do?
For assets like the property he has, he could arrange for joint ownership, so that the rights of survivorship will go to his wives and children upon his death. And
so what is he supposed to do? I didn't hear what you said. What is he supposed to do? I didn't hear what you said.
Joint ownership.
That is a principle, yes. But what is he supposed to do? Tell him what he needs to do. Hiyo joint ownership anafaa afanye aje? Unasema tu joint ownership. Joint ownership how? What should be done? Yes, come to your office is telling you, wakili, mimi sitaki kuandika will. Hii will naona ni mambo mbaya sana. Sitaki kuandika will. Niliona vile marehemu alikufa vile aliandika tu will pap. Mimi sitaki kuenda hivyo. Amekuambia hivyo. Anataka another alternative. So what will you tell him? Mithika, based on what we just said, what will be your advice to him be? So your advice in this sense would be go and do this. Okay. So what is he supposed to go and do?
To have the names of the other owners or the joint tenants included in the documents indicating the transfer documents to have to indicate the names of the other joint tenants.
Which joint tenants are these? Where are these joint tenants coming from? Where are they coming from?
I need someone to assist me kindly.
All right, somebody to assist, but I don't want anyone to assist you. But okay,
Madam, may I try?
May I proceed? Okay.
Oh, Cherono, let's go to Cherono first.
Yeah. I think what you're trying to put across is he can register the property as a joint tenant.
Is that your advice?
Can register. Yeah.
You're also advising that they need. So, your advice is very ridiculous. So you're telling him to go and transfer all his properties and register everybody as a proprietor.
No, this is for the point where for Joseph and the driver, he can go and register the property in both their names as joint tenants. So that when he dies, it will.
That is not. Somebody wants to provide for you. Do you tell them to register me as a joint tenant? Is that how you know? That is what I'm not understanding with the point that you guys are trying to put across. Joint tenancy. Because joint tenancy is now the property is registered in both their names. They're both owning the property together. Joint tenancy is not a mode of succession. If you want to give somebody property, you don't register them as joint tenants in any instance. You don't. So I don't know why you guys are having that. If you're giving somebody something, just give it to them, and that is all. Saying that you register the property as under joint tenancy doesn't cut it at all. Doesn't cut it at all.
So this will be like a gift in contemplation of death.
You guys are crazy.
Because how you get it? No, I'm getting confused.
You guys are crazy. Nancy, Oduor.
Mwalimu, what I'd advise Mr. Joseph is to register each person's name on the properties that he wishes to bequeath them when he's still alive.
Stop there. Robert Okiaga.
Looking at the question and how deliberate the testator is with words, in my own understanding, I think that the most viable alternative to this is a valid oral will.
But I'm not attack will.
No, it's talking about writing a will.
He doesn't want a will entirely.
But all the statements which I'm seeing here, he keeps repeating, writing a will, writing a will.
This person is simply saying that he doesn't want this concept of a will. This concept of a will, it doesn't, whether it's written or oral, he doesn't believe in it. So tell him what he can do with that doesn't involve a will. How can he provide for the beneficiaries without writing a will?
Another alternative, which in my view was weak, is setting up a trust.
Anyway, guys, we are moving back and forth, and this point is very clear. So anytime somebody is not willing to make a will, specifically to give the entire items to one specific person, then the alternative normally is a trust, a family trust. Okay, that is all they need to do. Register a trust. That is all that needs to be done. Register a trust. In the trust, we did trust in commercial. If you're not in commercial class, anyway. In a trust, anytime somebody indicates a trust, they will have to first appoint the trustees and also appoint mention the beneficiaries, and then they will tell or give directions in terms of how their properties will be utilized in that specific trust. So they will say that out of the trust fund, which is everything they own in that estate, one thing will go to this, let's say 10% will go to this person. Everything that he wants to bequeath these things. Remember, he's saying that he wants to keep the spirit of some 2 million shillings he was spending in the village. He wants to keep that tradition. Now that will be in the trust, where he will be saying that 2 million every year will be sent to the schools to school fees for the various children in the native village. And then from this, guys, the alternative of a will is a trust. In fact, sometimes the wills do create trust. So instead of having a will, people create trust. Even in a will, they will say that upon my demise, okay, everything that I die owning will be transferred to the trust. And then once you create the trust, then the trustees will have the directions. So you'll be indicating in that trust deed, for instance, that 10,000 shillings will go to my grandmother. This specific a piece of land will go to this person, or every year this amount will be withdrawn. So the alternative is to create a trust. Are we together? Guys, are we together? So there is nothing like you have to give gift inter vivos. No, this is provisions upon death. So we are not talking about inter vivos here. We are talking about how you provide for your beneficiaries when you die without having to necessarily make a will. Okay, and that is the question of having a trust. So you create a trust and then you provide the direction in as far as the trust is concerned within, the direction of disposing your properties within the trust. Okay, not gift inter vivos, not oral wills, you know. All right, so that is clear. Any question? Any question? Guys, are we together in terms of drafting a will and tested succession? I can take questions on tested succession. We can take questions on tested succession. Sorry, intestacy, so that we are clear. There's nothing much about probate that you need to worry about. They repeat the same thing all the time. Let's see, and let's go to the next paper and see what the questions were. We go to November of 2023. Did they have a probate paper that year? So this is taking its sweet time. ATP 102. Probate. All right, there. Do you guys wish that we do question 1? It's a few questions. Can we do question 1, or do you want us to adjourn? Like I say, I don't want to keep you here for long. So what do you suggest?
Let's
do
do
question
one.
Proceed.
We do question
Let's
1.
continue.
All right,
One.
read question 1.
Can I read?
Yes, please proceed.
Remy is a shrewd businessman with an expensive business venture in real property, hardware, and gold in Broadgate City in Kasambara Republic. Kasambara Republic has similar succession laws to that of Kenya. Remy is married to Fiorella, his childhood sweetheart. Their marriage was celebrated in the Roman Catholic Church, St. Peter's Square in Mount Pleasant on 3rd January 1996. They are blessed with 2 issues, Melody, a girl born in December 1996, and Shabalala, a boy born in October 2013. Fiorella works as the finance officer in Borrowdale County. She occasionally assists Remy in the business on matters finances and taxes. Fiorella is not a director in any of the companies. However, the businesses are housed on land in Borrowdale that is jointly owned. Specifically, the hardware and the gold shop are located in the expansive Sam Levy building on Borrowdale Block 12/209. The businesses are considered as family businesses, and sometimes Melody works there during her long college breaks, a tradition she has kept since high school. Besides Sam Levy building, the couples also had other properties which were owned individually. Fiorella owned several blocks of apartments, namely Borrowdale Block 12/1/120, Borrowdale 12/130, and a ranch in Mutare measuring 100 hectares that she inherited from her late parents. Remy, on the other hand, owned fleets of trailers, personal high-end cars, Borrowdale Block 12/100, Borrowdale Block 12/105,
Red City, Block 15, and Lovelace, Block 13/23. Kindly scroll. Remy and Fiorella are known to be great friends and have enjoyed a peaceful relationship since their celebration of their marriage. They served as role model to many couples and are often invited by the church to talk to young couples. Unknown to Fiorella, Remy had a love relationship with Therese, Melody's classmate and close friend, who was a frequent visitor to their household whenever the two had long study breaks. Theirs was a humble background. Melody, being a darling of his father, persuaded him to assist with topping up Therese's college fees. Therese had been enrolled into a self-sponsored program at the university to study law, but her Aunt Maggie, who used to pay her fees, died in an accident, and since then, paying fees became a challenge. Therese was overwhelmed by incessant love overtures from Remy and gave in to pressure to a relationship which they guarded. Remy reciprocated by paying her college fees and upkeep. On 20th October 2021, Remy claimed to have a business meeting in Red City, but unknown to Melody and Fiorella, Remy had taken Therese for an excursion. In an attempt to keep the family traditions of having dinner together by 9 p.m., Remy noticed that he was running late and decided he will make up by taking a shortcut to avoid the traffic jam after dropping Therese at her aunt's place. However, the route where am I?
Let me
my
scroll. Can you see?
I
You're here.
can't I think I'm lost.
You're here. Can you see? Can you see here?
Okay, yeah, I can. The route was bumpy, rough, with many trailers overlapping, and when he attempted to overtake.
You're now here.
Okay, thank you. His vehicle collided with an oncoming trailer. He rushed to hospital but succumbed after 10 days. Therese was devastated by the death of Remy. She was carrying Remy's child, and Remy had promised her a home in upmarket area within Red City. Remy died intestate. In March 2022, Borodale High Court, Fiorella began the process of seeking letters of administration for purposes of distributing the estate to the respective beneficiaries. However, on the 20th of May 2023, and before the administration process was finalized, Fiorella was involved in a grisly accident and died on the spot. Therese gave birth to a bouncing baby girl, Louisa, on 13th August 2022 and informed Remy's family that the children was Remy's daughter. She's also laying a claim on Red City Block 15902 based on Remy's promise to her. Melody has come to you for advice. Discuss the steps Melody need to take to ensure full distribution of the estate for her late father.
So Melody has come to you, and Melody is asking you to discuss the process the steps that they need to take to ensure the full distribution of the estate of the deceased person's estate. So first, you need to identify who is Melody. You come back to the question, and you look for the first instance Melody is mentioned. So we have Remy, that is the deceased person, right there. Remy is married to Fiorella, this childhood sweetheart. So Fiorella is there. That is the spouse. And then they have two kids, two issues. That is Melody there and Shabala right there. I'm just putting the dots for you. And then you're being told that Fiorella works as finance, of course, but occasionally assists Remy in the business and matters finance. Fiorella is not a director in any of the companies. However, the business are housed on land in Borrowdale that is jointly owned. Okay, jointly owned. Specifically, the hardware and the gold shop. And then you're told that the family business, and sometimes Melody works there as because Melody is the daughter. So those are the first issues that you need to identify. First, you need to understand the facts, guys. Reading the question once will not make you understand. You read twice. Okay. Now let's come back and discuss the steps. Mora Omwenga, welcome back. Help us answer the question. Discuss the steps that Melody need to undertake to ensure full distribution of the estate of her late father.
Okay, the first one is to petition the court for to make an application to court, sorry, for make an application to court for to be yeah.
Stop repeating words. You don't say no. We were here before, so can we calm down first? Sip something, sip a glass of water, and then let's go and talk about the question. Okay, which is what are the steps? So you tell me the first step is to make an application for this specific grant.
Make an application for grant of administration.
Which grant of administration is that?
Interstate.
Nancy, I will remove you from this class and you'll never come back. Try me again. Maura? Mute your microphone, Nancy.
Okay,
Yeah, make an application for grant of intestate administration.
There's nothing called intestate administration. What is the name of the grant? All right, you want to waste time again? You will make me very mad. Don't say Mwalimu anything. You will make me very mad. What is the question? The question is this. I'm going to repeat again. What is the procedure, or what are the steps that will be taken, a Melody, to ensure full distribution of the estate of a late father? What is the first step, the second step, until the last step?
Make an application to the registrar
Which
for
registrar?
grant.
Which registrar is this? Which application you make with the registrar? What is the first step?
A minute, I compose myself. You got me off guard.
No. Just like the kingdom of God. Answer the question, Mora. Please don't take me back where we came from. Just answer the question. There's nothing like composing yourself. Compose yourself as you proceed.
Okay. So, Melody will make an application to petitioning for respective grant.
Which respective grant is this?
Grant of administration.
There are 3 types of grants. Number 1,
grant of probate.
Number 2,
grant of administration.
Number 3,
grant of administration with a will annexed to it.
So which grant are we talking about here?
Grant of administration.
Which one?
I was a bit distracted. I didn't follow the question.
Whatever you're doing there will not be set in an exam. Keep getting distracted, but anyway, answer the question. This person has died intestate. Mora, you want us to go back to where we came from, where we took so much time. So please, whatever you're
Now
doing
I
there,
can take us through the process.
whatever you're doing there, please, can you concentrate so that you understand and answer the question? Or so that when this question is set again, because it will be set again, that is for sure. The process of administration, the process of getting a grant or succession is normally said all the times, either silently or directly, it will be said. So please, again, I would want you to pay some attention and take some notes. Okay. Is that okay, Mora?
Yes, Mwalimu.
All right. Somebody else answer that question for us. Somebody. Nyamoko.
Yeah, Mwalimu, if I may try. Yeah, Melody will petition the court for letters of administration of the state. And
for letters of administration intestate.
Yes, and she will attach an affidavit. To that petition, she will attach an affidavit.
Don't mention the documents. Don't mention the documents because there's 100% chance you're going to mention them wrong, and the examiner is going to deny you marks. So just say you make an application for the grant that you've said, of course, in the prescribed form and on the required documents. After that,
giving a list of all the assets and the list of all the beneficiaries.
Leave alone the contents of the documents. You make the application. You've made the application.
Once the grant has been issued, maybe it will.
Mugeni Nyamoko, grant imetolewa wapi sahi? You just said you make an application.
Yeah, you make an application, then the court will the notice will be given to the Gazette notice, inviting any objections if there's any.
Before that, you file the application, and then the application is first presented before a judge, where the judge will, of course, confirm that everything is proper, everything has been filed that needs to be filed, and then after that, you proceeded.
Yeah, then the a notice will be put in the Gazette notice for 30 days, and if there's no objection, then the grant will be issued. Now, after 6 months, if there is no objection, then Melody will apply to the court for confirmation of that grant. After that, now, then she will now be able to dispute the estate to the beneficiaries using the list of the beneficiaries and the list of the assets of the deceased.
Okay. All right. So guys, let's take some attention and personally and individually revise the questions to do with the procedure. So number one, what you ought to understand is that anytime you get a question asking you to discuss the process, the first process is usually you make an application for the relevant grant. You make an application for the relevant grant, and in this question that we have is the grant for letters of Administration intestate, of course, attaching the document. Don't talk about those documents. They're not needed. If the examiner wanted the documents, the examiner would indicate, list the documents that will be prepared or will be filed. So that is not a requirement here. That is not a requirement in this instance. So don't mention them. You don't need them right now. Okay. All right. Now, after that, then you proceed and indicate that that application is verified by the registrar. After verification, the file is paid before a judge, who then, after confirming that every detail is proper, the judge will proceed and direct that the application be gazetted in the Kenya Gazette for at least 30 days, inviting objections. Where there is no objections, the court will proceed and issue a temporary grant to Melody in this case. And then Melody will proceed and prepare the schedule of distribution and then make an application for confirmation. The court will confirm the grant, and then Melody will proceed and distribute the entire estate to the beneficiaries, and then file a report back with the court. Okay.
Thank you, Madam. Well explained.
All right. So next question is this: discuss steps Melody would take to administer the estate of her late mother and the properties that would form part of her mother's estate based on the above narration. Use the case law to buttress your answers. So let's go to Melody's mother. Melody's mother. So Melody's mother was Fiorella. Okay, so Fiorella owned some properties that first they had their matrimonial home. Number two, they had jointly owned property in Borodale County. So this one here, the one that I've indicated as orange, the gold shop as well. And then they had some properties that were owned individually. So Fiorella had Borodale Block 12/120, Block 12/130, and a ranch in Mutare measuring 100. And she inherited this from her late parents. Okay. So those are the properties that that this lady owned. Now, the same process of administering the estate of her late mother is that. So, but of course, what you need to understand is that the examiner is trying to set also the question of joint tenancies in an instance relating to matrimonial home. Number one, the matrimonial home. Number two is the jointly owned businesses that, of course, will survivorship. The principle of survivorship. The property will go straight to. Let me just come back. The property will go straight to the surviving joint owner. And remember that the person who has died first is Remy. Remy died first, and then the other person died second. That is the Fiorella died second. So the property will originally transmit to the surviving joint owner, and that person was Fiorella. That is the principle of survivorship. The person that died first will lose the property, and the person that dies last will have the properties. So that is the principle. Of course, public trust. Vijay Shrav as a public trustee also expounds on that point. Now, also we have section 43. Is it not 43? Actually 43, that talks about survivorship and joint ownership. So yes, so that is the aspect of distribution when it comes to joint ownership, where two people are owning a property and one dies and the other one dies later. So the person that survives the other, in this case, Fiorella survived Remy, and therefore all the properties that they owned together or jointly would ordinarily transmit to Fiorella's estate. Okay, and I've listed those properties. I've listed those properties like these ones here. So from this part, from that part, there are properties that she owned individually, and then the first one are the ones that they owned jointly. So that is as clear as that. That is as clear as that. And also remember that in this instance, this person has died before completing the process of succession, and therefore you just make an application for substitution. You make an application for substitution to be given the grant instead of the deceased administrator or the proposed administrator. That application must also be still be gazetted. It will still be gazetted. The normal process that I've said. Okay, anytime somebody is trying to take up a grant, they still have to be gazetted as well, and anybody might object. So we have to give that chance for anyone who wants to object. So the same procedure, but make sure that you have to make an application for substitution in this instance because they already started the process. So once you make that application, that same application must also be gazetted for 30 days. And then if there's no objection, then you receive the temporary grant that they ought to have received, okay, because they died in the process. So the same process shall follow. And then part C says that prefer a well-written opinion to Melody on the position of Teresa. I don't know let's just call him Teresa. Call her Teresa for the sake of moving on. Teresa and her daughter, okay, in the context of the law of succession. Now, who is Teresa or Teresa? Where is she? Yes, this is where yes, here. So unknown to Fiorella, Remy had a love relationship with Teresa, Melody's classmate and close friend, you know. So they had that thing going on for them, happy for them. And then you come down here, you are told that on this fatal day when after dropping this lady off, dies at a road accident. So that is the position. So they're not married, but they're girlfriends and they have a child together as well because the lady was pregnant and gave birth to Louisa, who is a baby girl or a bouncing baby girl, as the question says there. All right, so discuss the position of this lady in the context of the law of succession. Somebody? Yes, Alphonse?
Yes, I would advise that since Therese was not married, she's a girlfriend, and she does not fall under any of the classes of dependents under Section 29, so she will not inherit. But as for the daughter, since she is a biological daughter of the deceased, then she falls under the definition of who a child is, and also as a dependent under Section 29, she'll be entitled to inherit. So she's a dependent for the purposes of Section 29, and she's entitled to inherit. That is the dependent, the daughter.
Yes, so of course, that is the position of the law, that Teresa is not a beneficiary, or is not a dependent under Section 29 of the Law of Succession Act and within the entire section, because she is not married. She was not married to the deceased person prior to the death of the deceased person, and therefore also she is not a child of the deceased person. And for that reason, she will not inherit from that estate as a beneficiary. Now, the next point is that Louisa, who is the daughter, will inherit by virtue of being a child of the deceased person. Okay, so because the Law of Succession Act provides that children are dependents under Section 29A and they will inherit without having to show maintenance. Okay, they're entitled to that estate without having to show maintenance. Guys, are we together?
Yes, we are, Mwalimu.
All right. Any question? All right, let's take as many questions as possible. Tianga, we start with you.
Mwalimu, a child who is taken in, maybe just for purposes of maybe the testator paying school fees for that child, where does that kid fall?
You tell me. Where do they fall?
I don't know if they're the ones who are supposed to show maintenance. If at all, it's just school fees. This the testator is paying.
Stop there. Stop there. Are they beneficiaries with the estate? Okay, these are very basic concepts that we've discussed in probate. That by now they should be at your fingertips. They must be at your fingertips. At this point, when the exam is next week, you need to know who the dependents are. Who are the dependents under Section 29? So tell me, a child that was taken in, are they dependents or not? And how do they inherit from the estate of the deceased person? Tianga Jennifer.
A child that was taken in is a dependent, but they inherit after showing maintenance.
Exactly. So your question?
So I think maybe what I'm trying to ask is, because I think this is the second time I'm seeing such a question. So this girl, Teresi, because the testator was paying school fees for her, can we categorize her as a child taken in by the testator?
The answer that I was supposed to give is a very funny answer. But because of morality, I will not mention that answer. How do you sleep with the child until the child is giving birth to your child again?
Well, it's not a question. We are not denying morality here. I'm just, because I've seen that question.
No, Jennifer, that is common sense. Is this person a child? Is it a child of the deceased person? Is he a child?
No.
The question says this lady was pregnant with a child of the deceased person. Now, regardless whether it was paid, the school fees was paid or whatever was paid, does this person become a child of the deceased person?
No, prior to her being pregnant.
Listen, don't stop playing. Is this person a child of the deceased person? Were they taken in as children of the deceased person? Answer the question yes or no. There's no two way around it.
Mwalimu, I think that is where my confusion is coming, and I think that should have been the question.
No, the question is, were they taken in as children of the deceased person? Yes or no?
Mwalimu, let me ask for the taken in part. Does it mean that coming into the fold, living with this family, or taken in, just paying school fees alone also constitutes being taken in? I think that should have been the question.
Taken in is an English word. Take in, chukua, ndani.
Okay, then
were they taken in?
Okay, if that is the case, then no. I think I'm overthinking it. Sawa. I'm answered, Mwalimu. Thank you.
You are not, by virtue of being paid school. Getting school fees doesn't make you a child of somebody. People take their wives to school. You marry a lady, or you marry your husband, and you pay your husband school fees. And the question simply says this person, even at the time was dying, they were coming from whatever they were coming from, and this lady was actually pregnant. So how then do you claim that this lady was a child of the deceased person? So you can't be a child if you are pregnant for the deceased person. Doesn't beat logic. Or doesn't. So they're not children. So in terms of maintenance, there are two things: you are taken in as a child, or you're just being maintained. Those two people are related, but somehow different, but also related. So if you're taken in as the child of the deceased person, then you, so long as you show maintenance, you will be inheriting from the estate of the deceased person. Okay? But if you are being maintained by the deceased person, okay, as a child, without being taken in, then whatever you can benefit, whatever you get is limited to the maintenance. I hope that is confusing somebody, so let me explain it again. Okay? The deceased person, there are two people here. The first person is taken in as the child of the deceased person. Okay? Now, this person must demonstrate that before the deceased person died, they were still being taken care of by the deceased person. And because they were taken in as their child, they will inherit from that estate as children, but of course, still showing that the deceased person was still taking care of them. Because there are certain instances where somebody was taken in and then they moved out later and got married somewhere and then moved on with their life, just like the question in June 2021, that they were married, sorry, not married, they were taken in when they were kids, they grew up, and then they were married, they left that home. Now, in that instance, they were no longer being maintained. Though they were taken in at some point in future, in the past, they are no longer being maintained. And then there's another person who is not being taken in, but is being maintained as the child of the deceased person. Now that person will also be entitled to inherit from that estate, but to the extent of what the deceased person was doing for them. So if you're getting school fees from the deceased person, you will only get school fees from the deceased person because that is exactly what he was doing for you before he died. Okay? If you're taken in, if the question specifically say this person was taken in and treated as the deceased person's child, then they are children of the deceased person by virtue of that. So they need to demonstrate that by the time the deceased person was dying, they were being maintained, or not really maintained, but they're being taken care of by the deceased person. And then there's a second person who is not taken in, but was being taken care of as a child by the deceased person. Now this person also must show maintenance, and whatever they are going to get is limited to what they're being given. So anytime the question says that this person was paying for them school fees, or was paying their rent, or rent and school fees, that is exactly what they will get. They don't get more than what the deceased person was giving them. Are you together?
Yes, Mwalimu, thank you.
Alphonse?
Yes, Mwalimu, I actually have one clarification, and I just wanted to bring to your attention that we discussed the issue of substitution in B, and the lady, that is Fiorella, is the one who had already begun administering the estate of the husband. So we were supposed to discuss it under A. Then now the clarification that I was seeking is being that we have not been told that there was a matrimonial home within the facts. Like I've looked through and there is no specific mention of matrimonial home, but of course there is that implication, like we can imply that there was one, but it has not been explicitly mentioned. So do we come? Yes.
Unless it is mentioned, you can't mention it in your answer.
Okay, thank you.
Yeah. Don't imply. Maybe they didn't have a home. They just living differently. All right. Janine?
My question is, as you were drafting a will, there was nominations were mentioned. Do we also include them?
Yes, we were not. That was a different question. When somebody mentions nomination, for instance, they are saying that my shares will be dealt with according to my nomination. That is exactly what you say in the will. So you'll be saying shares in this company, and then you indicate the shares in this company will be distributed according to my the nomination instructions. You just mention whatever you mentioned in the will.
Okay,
Are you
that is
answered?
clear. Thank you.
Yes. So we're not saying you're distributing that property differently in a will. No. Remember that nomination, property subject to nomination are not distributable in the will. So you only indicate that this specific item will be distributed according to the rules of nomination. So we're not distributing them, we're just mentioning that they will be distributed according to the rules of nomination that you already gave, the direction that you already gave earlier. So just copy paste what the deceased person said about that property. And if it was because when you're having a will, making a will is easy because you already have everything. You already have everything that the deceased person have, and therefore you just proceed and copy paste and put in fill in the details regarding, I mean, depending on what the instructions are. So if they say this is how my property will be, that is exactly what you say. This is how I will be buried, that is exactly what you say. So it is a little bit easier when you're dealing with a will that is already structured, like the one that we were looking at. It is already structured, so it is easy for you to or easy for the person drafting the will to walk around it and draft it quickly. So just copy paste, say this will be done, this will be done, this will be done. But of course, as you do that, you remember that there are certain properties that can't be included in the will, can't be bequeathed in a will. We're not saying they can't be mentioned in the will. They can be mentioned in the will, but they can't be bequeathed in a will. For instance, joint tenancies. Okay, you can say that the money that I have in this bank shall go to this person according to the rules of nomination. That is okay, but you can't distribute if there's already nomination. You can't give that specific property to somebody else if it is under nomination. You can't give that specific property to somebody else if it is under survivorship or donation. Are we together?
Yes,
All
that
right.
is clear.
Chula moyo ama chula moyo.
Yeah, I have two separate questions on question B and question C. My first one for question B is you see when you're mentioning the application for a substitution, would we have to be specific to it's the grant of letters of administration, the bonus? Like, do we have to be specific, or do we just say substitution and it's enough, as opposed to being specific? Maybe you could be wrong.
Specific with what?
Because if we're saying the administrator died and now I think it's Melody that Melody now wants to continue the process, wouldn't we be applying for the grant for her to take over, which then would be the grant of letters of administration, the bonus, yeah.
No, there's no debony there. We don't have the debony I mean as of now, because there was no. When do you get a limited grant debony? You get a limited grant debony when the person was already distributing and he has not completed distribution. That is when you go for the limited grant debony. In this instance, he was already starting the process of applying for the grant and he died.
Okay.
So you just need to make an application to replace him as the proposed administrator.
Okay, so
Yes,
that's fine. And then the second question is just a more pragmatic, as opposed to like a. 'Cause I'm thinking if it's 7 marks, how are we consolidating the 7 marks? Because like we've discussed the section 29 of why the mother could not be, and then also the same way section 29 of why the child could be, and probably you throw in a case, and maybe I'm thinking also Article 53 of what's a child, but I'm still struggling to see how with what we've discussed so far, how we get to 7 marks, unless the explanation also is part of the 7 marks.
It's a very simple thing. Let's go there. So we have two people there. The first person is Melody, and the second person is not Melody, Teresa, or whichever that name is, and the daughter. So you start with the mother. Is the mother a beneficiary under the provisions or within the provisions of the Law of Succession Act? No, she's not. She's not a wife, because who is defined under the wife? I mean, as a wife in the Act, either the wife married under the Marriage Act or the spouse married under the Marriage Act, a cohabitee, or a woman under Section 3(5). She doesn't meet those three qualifications. Okay, that is the first one. And therefore, because she doesn't meet the qualifications of being a wife, therefore she does not even fit within the meaning of Section 29, which is now the list of beneficiaries, or the list of dependents, which includes the wife, wives or former wives, and then the list goes down. And then, for that reason, she's not going to inherit from that specific estate. And then we go to the child. Is this person a child? That is the first one. Are they the children of the deceased person? And of course, you know the rules of children. So you start by the fact that a child is defined under section 3 of the Act as one that is born of the deceased person, provided they're born alive. Okay, that is the first test. The second thing is the time of birth. For you to be a child of the deceased person, so when you are born after the deceased person has died, you must have been born within 1 year from the date of the deceased person's death. Within 1 year, assuming that you are the last business the deceased person did, then they died, or they died in service, in active service, and therefore we give you 1 year from the time they die to be given birth to. So if you give birth to a child 1.5 years after the deceased person died, you can't claim that person is the deceased person's child. Doesn't make sense. So we go there. This person was given birth to a few months. Let's just confirm. On the 13th of August 2022, and the person died in March 2022. So yes, so it's still within 1 year, and therefore is a child. So the fact that we've established that is a child, then now we establish his right to inherit, which is under Section 29, where we provide that under Section 29, the children of the deceased persons will inherit from the estate of the deceased person without showing any form of maintenance. Without showing any form of maintenance. So that in itself, those two provisions will give us, or the analysis itself will give you the 7 marks. Are you together? If you go to an exam, and you find a question saying 1 + 1, and then it tells you 50 marks, just write 2. It is 2, and you get 50 marks for 2. Don't say, nah, this can't be 2 marks. This can be, 50 marks. No, just write the answer, the right answer, and move on with other questions. So guys, that is that.
Thanks.
All right, thank you very much. Mora Omwenga, are you there? Today is your day. Mora, are you there?
Yes, I am, Mwalimu.
Yes, I gave you some time to collect your thoughts. What is the process of administration, or the process of taking out a grant, so that we can adjourn at that point? Number 1.
Okay. I make reference to the question we've just had.
No, just generally.
Okay, you make an application for relevant grant, and then the application is verified by a registrar. After verification, it's tabled before a judge. If there is a will, the will is propounded. If there is no will, the judge makes an order to advertise the application in the Kenya Gazette. Then the application is gazetted. After gazettement, if 30 days lapse without any objection, the letters, interim orders.
Which orders?
The inter. Okay. The interim
Stop
grant.
cramming. Hey, stop cramming. Whatever you're writing there, you're cramming that thing, and it's going to confuse you more. So
And
where there's
a
no
grant
objection.
is an interim grant is issued. Then a letter of a schedule of distribution is prepared.
By who?
And then brought back by the administrator, by the personal representative.
Don't say brought back. Then the court is not concerned with the letter with that. Don't say brought back. It is prepared by the person. When do you prepare the schedule of distribution? When?
After the.
Under what circumstance? Under what circumstance?
When there is no objection to the Gazette notice.
No, not that. I'm asking a different thing. When do you prepare letters of? Do you prepare a schedule of distribution all the time?
When there is no will.
Yes, when there's no will. Proceed.
Okay, and then there is the schedule of distribution is tabled back to the judge.
What do you
If
mean
they-
tabled? Don't use the word tabled.
Is no, how do I put it?
What is supposed to happen after you prepare the schedule of distribution? What is the next thing you do?
Taken back to the.
Don't say taken. That is a pedestrian language. What do you mean taken? What do you do once you prepare the schedule of distribution? And within what period of time?
Okay. Now, the schedule of distribution is prepared within period. Maybe I continue and then.
No, you can't continue until you answer that question. Within what period of time?
Now, after a temporary grant has been granted by the court.
You've been given a temporary grant. Yes. What do you do now? What is the next thing you do? You have the temporary grant. What is the next thing you go to?
If there is no will, the parties will move and will prepare distribution schedule.
Which parties? Which parties are these that you're making reference to?
The person who was petitioned, the personal representative will prepare a distribution
And in this
schedule.
instance, who is the person? What do you call the personal representative in this instance? The instance you're making a schedule of distribution. What do we call that?
An administrator to the estate of its.
Proceed. Quickly, we need to adjourn, Nora. We need to adjourn.
Now, and then
So they have prepared the schedule of distribution. What next do you do after preparing it?
Then an confirmation of grant by the court.
So you prepared it in your house. Then the judge will just dream and say, "Oh, I think Mora's prepared it." What do you do?
Now, you told me not to use the word bring it back to the court.
Bring it back is pedestrian. That is not even a legal term. What do you mean bring it back? Is it bread you went to buy back and you're not bringing back? What do you do? Mora, please. Let's complete in a good note.
Oh. Now, the schedule of distribution is returned back to.
What do you mean returned? Kwani ilichukuliwa court? Was it taken from the court? All right, I think we are wasting time. Now let's do this. You go do that process and then let me know once you're done doing it yourself. We can release everybody else. I'll stop the recording. That is your assignment, Mora. That is your personal assignment.